as agreed to by the Learned Council for the parties, the registry to list this matter again on
On 1st of April.
01/4/2025.
It's obliged.
Hope you do that on
Yes,
that day.
we will definitely do.
You know the day. So it's better you do it.
Yes, madam.
Okay. Yes.
My lord, I beg to mention item 2 and 3 on the part 2 list, my lord. In fact, these matters are all matters and they are fixed for tomorrow. But my lord, I have to take further instructions from my client regarding whether he will be engaging some other counsel. And
Okay,
I've already
we'll pass
taken...
the orders tomorrow. It's already fixed for tomorrow. We'll pass the orders tomorrow. Don't
My
worry.
lord, my lord.
So you're
Obliged.
not doing the matters. Okay.
My lord.
But don't take a long, because it's 2013 matters.
Exactly, my lord.
Mr. Malhotra is not here. You can have it next week. Okay?
My lord.
Yes.
Lordship, regarding item number 10, I would like to mention that I have applied for a copy of evidences. So,
Give me. Ask the registry to give me. Huh? The file has to go. Oh. Under process. So they'll require the file. Or it will be taken from here. Okay, so I'll fix the, when can we fix the matter? How long will it take to give him? 2 days. So this week, we'll have it next week. We'll fix it next. Item number 10. On the prayer of the Learned Council for the appellant, who has submitted that he has preferred an application for being granted the certified copies of the evidences.
Daily list for motion, item number 1.
Your Lordship. Your Lordship, this is a contempt petition filed by the petitioners against the respondents for the willful and deliberate defiance of this court's order, which was passed in WPC number 131 of 2024, wherein the direction was made to the respondent, which is the district collector of Siaha district, to issue a fresh award in terms of the 2013 Act, which was made, also, Lord, in the direction it was passed that it should be concluded within a period of 5 months. But then it was duly received back in the writ petition, Your Lordship, the award number 1, additional
So why
1.
have you filed this contempt petition?
Your
Because your
Lordship-
senior told you to file. Huh?
Lordship.
Why?
Because, Your Lordship,
When can I exercise my contempt jurisdiction?
because, Your Lordship, this court has ordered the respondents to take actions as per the directions, and the certified copy of the order was already received by them on
So
the...
when did this contempt occasion?
It was
Madam,
2000.
let her. Yes.
Your Lordship, this was passed
On
on
which
25.
date the contempt happened?
Your Lordship, this was passed on 25/2024,
Okay.
and they were given 5 months time.
That is what I wanted. Hud, your name?
K. Venetia, Your Lordship.
Learned Counsel for the petitioner. The present contempt petition has been preferred, alleging violation of the directions passed by this court by order dated 25/2024 in WPC number 131/2023. Full stop. The petitioners have also brought on record a communication dated 11/6/2024 by which the certified copy of the order dated said order dated 25/2024 was forwarded to the Deputy Commissioner, Deputy Commissioner Sihaha, SIAHA District. So accordingly, issue notice. Upon the, but here, the award is to be passed only by the respondent number district collector.
For Your Lordship.
4. Notice, registry to issue notice at this stage only to respondent number 4. Full stop. Petitioner to take steps for service of notice upon the respondent number 4 within 2 days. Notice be issued by way of registered post with AD. Registry to list this matter again after 4 weeks on a date to be fixed by it.
Obliged, Your Lordship.
So it's on the completion of that day that the violation occasions.
Item number 2 for admission.
May it please your lordship, yesterday the respondents
Where is that? Where is madam?
called to
You are
show
appearing for the private respondent.
Yes, my lord.
Okay. What is your locus to have filed that review?
Your Lordship, this is a family property.
Not. It is a property brought by the husband of the, LSC is in the name of the husband.
LSC is in the name of the
Husband.
petitioner's husband.
And the money
But
went from
I,
his,
I sold my ancestor's property and we purchased and we
but the
contributed.
money went from his, where is your statement to that effect that before, in the review petition that you have brought this property?
Page number 29, point number 4.
29. This is your application for review.
Review.
Okay.
Yes, Your Lordship. We sold the ancestral property at Kolian village at the request of the petitioner's husband. And we migrated to Electric Veng Aizol. And we started staying in the rented house at
Just a
Electric
moment,
Veng.
sir. When was this property brought by the husband?
My lord,
2023.
the sale deed is at page
No, give me the date only. Give me the date.
date. Page 16, my lord. Sale deed, 30th January 2023. And, my lord, though they have stated that they have contributed the money, they have no proof as such.
No, fine, forget it.
And at page 22, my lord, page 22, this is the account of the deceased.
No, I've seen it. It was debited from that account.
Yes. And 21 lakhs was debited from the account.
Mr. Counsel, you have said that you have migrated in the year 2011 to Aizol.
Yes.
From
yes.
your, by selling your ancestral property.
Yes, Your Lordship.
Where were you staying? Because this property
Electric
was,
Veng.
this property was brought only on 31/2023. And
Yes,
this
Your Lordship.
property is situated where?
Zuang Tui.
It's in a different place.
Yes.
Huh? So, electric wing, whatever you have, it's fine. But what is the connection with this land, which is there? Where is the schedule of this property?
Your Lordship, while we were staying together in Electric
The husband of the petitioner.
We were staying together, in Lordship. We were staying together in the same place.
No, electric wing, I understand.
Yes.
That's your own property?
A rented house.
A rented house.
Yes.
You're continuing to stay there? Where are you staying today?
Zongtui.
In the house of the...
In
the
our house.
The lower court records have come? LCR has come? The lower court records will not be required, I suppose,
Yes, my lord. It will not be required, my lord.
because everything is here.
Everything is here.
Both of you agree? The lower court records will not be required, because the materials are here.
Yes, sir.
It was only a review application that you are putting to challenge.
Yes.
Okay. Any pleadings you want to bring on record? Nothing?
Nothing, sir.
Nothing. Heard Mr. So-and-so, learned counsel for, we are fixing it for hearing, final hearing. So-and-so and also Mr. So-and-so, learned senior counsel appearing for the respondents. Counsel appearing for the respondents. So, as agreed to by the, Mr. So-and-so, learned counsel for the respondents have submitted that he would not be filing any further pleading in the matter, any affidavit in the matter, full stop. The parties have also submitted that, learned counsel for the parties have also submitted that the necessary material required for disposal of the present appeal is already available on record, full stop. Accordingly, the parties have submitted that the matter be taken up for final disposal at an early date, full stop. As agreed to by the learned counsel for the parties, a registry to list this matter again on, how about 20th? 20, you are free? 20,
Of this month.
yeah?
Fine.
Why keep this pending? We'll,
Yes,
if
yes.
you are agreeable,
Yes,
I
sir,
can
lots of-
take it up today itself. But anyway, I'm not taking you by surprise. 20th, right?
Yes, Your Lordship.
For, on 23/2025. Full stop. For, this has been admitted?
Not yet, my lord. They are newly represented.
Okay.
Item number 3.
Right.
Obliged, my lord.
Yes, madam.
Lordship, I'm appearing on behalf of my senior CGC. Your Lordship, as per the last court's order, the respondent, the learned counsel for respondent number 15 has paid for further time to file her short course reply. And and the learned counsel for the respondent 15 is on leave, Your Lordship.
What is the order violated? What is the direction?
Lordship, the order was passed on 3/9/2018.
Have you seen the affidavits filed by the respondents?
Yes, Your Lordship.
Therein they have brought in a verification report wherein they say that they can't identify. Huh?
Yes.
The damage also cannot be identified.
Lordship, at this
Now she
stage-
comes up.
At this stage, so far as my knowledge, what is made by district collector.
Ah.
However, whether it's approved by the government of Mizoram, I don't know. I have,
We are least bordered, we are bordered with our, bothered with our directions only.
yes.
And they have said that if your land passes are valid, verifiable, fine,
Yes.
go ahead. Now they say it's not. So where is the violation?
The
If you want-
violation is, Your Lordship, I'll come to that. It is, I have a reply affidavit.
Your reply affidavit, we will not hear, we are not here
Yes,
to
yes.
adjudicate the issue.
They have filed earlier, but the development is there. Since they have issued land record by the MADC,
That's why you come back. You come back with a writ petition, but
Your
here,
Lordship, at this stage, I may allow to.
Uh-huh.
It's even this award is furnished to the BRTF. They have no objection so far, Your Lordship.
madam, we are concerned with our directions,
Yes,
okay? That within, there was a team set up, right?
yes,
At page 28, 29, a verification was directed.
yes.
Then the deputy commissioner, respondent number 4 shall take decision with regard to the petitioner's number. So who is respondent number 4?
4 is DC.
DC.
DC accepted the.
If the petitions are valid and give heritable transfer, they shall take a decision as they want, whether want to, so and so, so and so. Now you come to the report,
Yes,
joint verification report. That is annexed at
only
multiple.
that verification report says that the record, land record is not there.
Yeah,
However, the DC asked Revenue Department, MADC, to submit. So they have submitted and it's accepted and made an award.
Come to the affidavit filed by 2 and 9.
Your Lordship, I have seen that, but they have, it's incomplete. They have not enclosed the accepted order.
Have you brought it
Yes,
in your reply?
yes,
Where?
I'll come to that. Kindly see the so-called reply filed by the MADC, revenue officer, wherein, we got it, Your Lordship, it's filed by Nazi Kaila.
What does he say?
Yes. Annexure 2, the order of the DC. We got it, Your Lordship?
This is by respondent number?
Respondent number 14, filed by 14. So-called reply, filed by 14.
Yes.
You got it, Your Lordship,
Huh.
page 11, Annexure 2. I'll read out. In persons with Honorable High Court order passed in such, I'll come from the second para, Your Lordship.
Just a
I'll read.
moment, just a moment.
Here, Your Lordship, I'll come from the second para.
No, where is your case number here, the WPC number?
Yes.
Yours is
My
79?
case number is WPC number
79?
79. Yes. My case is there.
Where is your case reflected here?
78. The second one, 79,
79,
of
okay.
2018. Your
Whereas
Lordship.
senior so-and-so has submitted letter clarifying that they failed to produce original during the course of hearing due to the fact that land records were maintained, so-and-so could not be traced out. The BNR has informed that we have only MADC to confirm the ownership and no other all records. They are requested to take a decision, so-and-so. Says that the road construction has been completed more than so acquisition of land after lapse and so on. And submitted records, submitted reconstructed land records for acceptance of the meeting to discuss is conducted on so-and-so. Decided that reconstructed revenue shall be submitted, reconstructed forwarded to further conservation. The senior revision submitted that a letter dated which was received by the reconstructed the land records in respect to land process and the tax payment receipts and other relevant documents and the last one. How can you go and do this? This is beyond what is being directed.
Yes, Your Lordship, after that, we have the senior revenue officer submitted the records and forwarded
He
to
did
the
not submit any
BRTF.
record. He only, if you had the, or he was says that he had referred to the original land passes and the tax payment receipts. That means
Yes,
you have an
yes,
original land
yes,
pass.
Yes, yes.
Why was that not verified in the spot verification?
It's verified. At
But
that
that
time,
they say that it was verified, they bring on record and
verified, they asked for the land record that time. They could not produce at that time. So the DC, Siha called for the record. And
Yes, madam. What is your stand? So what has happened thereafter? Nothing.
Now they have proceed the case. They have made award. This also forwarded to the.
They have made an award
Yes.
in pursuance to the directions of this
Yes,
court.
yes.
What is left here? If they have made an award, that is the end of the
Yes,
matter.
the approval is whether the approval is there or not.
No.
That's why the district collector, respondent number 15, has to submit before you, Your Lordship. This is the
They have acquired your land or damages?
Yes.
Acquired.
yeah, acquire.
Acquired your land.
Yes. This is the award.
Who is appearing for the respondent number 15?
15 Mary.
She is not keeping well. No, I think you are for 15.
No, my lord.
This is they are from
Who is appearing for respondent number 15?
Mary. He's not present today.
Not in the
She's
court
not-
today.
Not in the court today. Yeah, she submitted leave application, it seems that.
A prayer is made on behalf of Mrs. Mary L. Kengte, Lanark Council, appearing for the respondent number 5 for an accommodation today on account
15,
of
Your Lordship.
respondent number 15 for an accommodation today on account of personal inconvenience. For so prayer is not objected to by the Lanark Council for the petition. Accordingly, the registry to list this matter again on 24/3/2025. On the next date of listing, Ms. Mary, Lanark Council for the respondent number 15 shall apprise this court as to the further developments taking place in the matter and the status of implementation of the directions passed by this court via the order dated 3/9/2018 in WPC number 79 of
2018.
2018. Let's see.
Oh, please.
Item number 4.
Yes, who is appearing for the respondent number 1? You are appearing.
My lord, my senior Mr. L. Mahota he used to be the standing counsel of the MZU, my lord.
So you will be appearing for respondent
He
number 2
used to
also?
appear, but he is no more the standing counsel, so I don't think he will be representing the respondents anymore, my lord.
We'll have to issue notice to the respondent number 2.
My lord.
Full stop. This court had wide order dated 14/2 2025, passed in IS bracketed C number 19/2025, implemented the respondent number 2 as a party respondent in the present proceedings. The petitioner has thereafter filed an amended cause title incorporating the name of the newly implemented respondent number 2. FUSA, in view of the above, raised issue notice to the newly implemented respondent number 2. Petitioner to take steps for service of notice upon the respondent number 2 by way of registered post with AD within 3 working days from today. Registry on receipt of such requisites from the petitioner shall issue the notice. Also, the matter be listed after 4 weeks along with a report pertaining to the status of service of notice upon the respondent number 2. 4 weeks.
Obliged.
Item number 5.
Yes, madam.
My lord, respondent counsel cannot appear today, Miss Mary.
Okay, that's same order. Adjourn go Bahali. We have adjourned it, ma'am.
Item number 6.
May it please your lordship. My lord, in this case, I have three proposed substantial question of law for consideration of your lordship. It's a second appeal, your lordship.
All the three,
My lord.
somehow, you'll have to satisfy me.
Yes, your lordship. I'll try my best. So the subject matter of this appeal is arising out of a probate case, your lordship.
There is concurrent finding of both the courts.
Concurrent finding, yes. Notice was not issued, number one. Number two is that, your lordship, the subject matter which formed,
The land, you say, the character of the land has changed.
it's no longer in existence, that particular pata number.
It has gone, there was another LSC issued in that.
Yes, the testator during his lifetime had bifurcated that land. So that particular LSC, the land settlement certificate, which forms the subject matter of the will, no longer
And
existed.
see, this two legatees, that has not occasioned. It
No,
is said
I've-
that it will be for that lady who is not keeping, who is disabled,
Disabled.
and or
Anyone
the
taking care of.
taking care of. So
There-
it's not that, it's for that lady only.
Correct.
So
Now
the
the-
three is out.
No, my lord, I've reformulated the third substantial question of law, which I've just submitted. There was material suppression of facts. The reason being is that, as per the will, the second benefit, the second legatee would be anyone who takes care of our sister, that Ruthi, the present respondent. Now, what the petitioner in the probate case suppressed was that there are two guardianship certificates. One issued in favor of one lady.
And
called-
both these guardianship certificates are holding the field, you have not challenged it.
No one has challenged that.
No.
Because when the will was probated,
One of the guardianship certificate is to you.
yes, to
Which
my
one?
sister.
She is a party here.
No, she's not.
Then she has got no grievance. How was this
But-
issue dealt with by the
That issue was not dealt
appellate
at all.
court?
That was not dealt.
Where have you raised that issue?
That particular issue was not
Then-
raised, but
then-
it's nevertheless an
then-
issue that needs to, determination,
If
Your
you have
Lordship.
not, if that issue is not determined by the, you have not taken that issue, whether, it's not a question of law, it's a question, mixed question of facts.
Mixed
and
question of law, in fact, I understand.
Then how can it be a substantial question?
No, because the reason being is that, as per, to give effect to the will, the second legatee has to be determined. And for that, evidence has to be adduced. No evidence whatsoever was taken.
No, it's a probable situation wherein, because who would be taking care of her at the time of her demise cannot be determined as on date.
The reason, another
Because
issue.
if your sister has a guardianship certificate and the other lady also has a guardianship certificate, if both are clash, there is a clash, either of them
understand.
should approach the,
Understood. I believe, I understand that, Your Lordship. I
Yeah.
understand that. But the first issue remains, whether the will could have been probated without issuing any notice. Notice was not issued at all.
and that is not a ground you have taken up in your appeal.
I have, Your Lordship.
You have? Show
Yes.
me. How was it dealt with?
The memo of appeal,
No. The order,
which order, Your Lordship?
the appellate court's order.
All right. That is at the number 1, serial number, Roman number 1 that we've, in the certified true copy is annexed.
I'm with me.
Your
You
Lordship.
can proceed.
Para 10. Appellant also challenged in this appeal that opportunity was not given to her before passing of the order dated so-and-so in probate case number so-and-so, allowing probate of the will left by Shri R. Sankima, and that there is no date and year in the said will, and the learned lower court erred in law in probating the will before proving its genuineness and a court fee of so-and-so. Section 29(8) of the Mizoram Marriage Inheritance of Property Act 2014 read, the probate of a will must be made within 5 years from the death of the testator. The probate application was filed by the petitioner, Ms. So-and-so. As she is a Down syndrome person, she refiled the said application to her legal guardians with so-and-so under Section 30 of the 2014 Act, and was received by the Learned Court of the Senior Civil Judge 4 on endorsement. The will is reproduced in para 13. And basically, the conclusion is that since I was not a legatee or even a witness, there was no requirement. That was the conclusive part as far as that opportunity is concerned.
The will was probated after it was demonstrated by following that basic tenements that you have in your.
Yeah,
that
basically, with,
that will was probated after it was demonstrated that it was the last will of the testator. There was a witness.
the witnesses were this thing.
One had died, the other one was there.
Yes.
So, Evidence Act 68 was complied with.
70, yeah.
And who are you?
One of the-
How are you related to the testator?
Yes, Your Lordship. Our father, R. Sankima, I am the daughter from the first marriage. I am the daughter from the first marriage. Whereas the, my disabled sister is the daughter from the second marriage. Whereas the legal guardian who is representing the,
Rosalina, huh?
yes,
Huh.
she
Rosangliti.
is the daughter of my mother-in-law from a different marriage. She does not stay with us. She is married, living with her, maintaining her own house with her husband, and she has never lived with us.
Need not be, she is only a guardian here.
Correct. So that basically is the crux of the case. Otherwise, myself, during the lifetime of my parents, even after their death, this Ruthi was always living with us. Always.
Now, in a probate case, where is that order of the original court?
Page 31. Three one Annexure 7. May I read, Your Lordship?
Annexure 7. You have not challenged the will.
In order to challenge the will also, I have to be given an opportunity. When I was not aware that a will existed, that the
No.
will had been probated,
Now.
where was the opportunity, Your Lordship?
The testator's daughter is the person suffering from Down syndrome.
Yes.
So he has given it to her daughter.
Basically,
To her daughter.
the disabled daughter.
And have you brought here anything to show that the land was not of that person or the thing was not of that person? You have not.
Our
The
father
property that he has devolved was his own property.
there's no question on that. There's
I'm
no
sorry,
question on
not
that.
satisfied.
But, Your Lordship, another issue is at page 64, annexure 15.
I'm not dismissing it. Try your luck.
It's all right.
I'm sorry.
Just one point, Your Lord, just one point. I understand. I appreciate Your Lordship's giving me an opportunity. But at page 64,
Maybe I'm
annexure
wrong,
15.
but I don't want you to have, but I'm not convinced. Yes, madam. Anything to hit the nail?
Will is
in the
not
coffin?
challenged.
Huh?
Will is not challenged in this appeal.
That is too timid. Anything more? So that I can
Then-
tilt
then-
finally to you.
Then the same is reflected in the judgment
Judgment.
and order passed by the appellate court.
As agreed to by the Learned Council for the parties, raised it to list this matter again on 25/3/2024. I'm sorry, I could not bring myself.
Not very well, Your Lordship.
Much obliged.
Try my luck.
Item number 7.
Because that will, you have not been able to show anything. Your case is the guardian.
Correct. But the property is not in existence anymore.
That's a different thing. That day, if it is probated also, it will have no effect.
Correct.
But for that, your basic thing is that you want to be the guardian of that lady. But the person who wants to be the guardian is also not before the court.
Correct, understood.
Maybe, try.
Yes, Your Lordship.
Anybody appearing for 1, 2 and 3? No.
My lord, regarding respondent 1, 2 and 3, the service report has not been received. So we are awaiting the service report from the respondent 1 to 3. Whereas for respondent number 4 to 6, they have the AD card has.
4 to 6 may not be in a position to take
Yes.
a decision in this line.
My lord.
Seen the office note dated 10/3/2025, which reveals that the service report upon the respondent number 1 to 3 have not been received. The notices upon the said respondents were issued on 21/11/2024. Full stop. Considering the long lapse of time since issuance of notice, the Learned Council for the petitioner is directed to take fresh steps for service of notice upon the respondent number 1, 2, 3, 1, 2 and 3 by way of registered post with AD. Steps within 3 working days from today.
Obliged.
Item number 8.
Yes, madam.
My lord, the counsel for the respondent, Ms. Mary, is unavailable today.
Okay, you satisfy me. You were the person who had, this compound, it's called Razuk. How do you pronounce that?
Rakzu,
Rabzu.
yes,
It's a drink,
yes, my lord.
right? You had sent those people to buy that.
Allegedly, my lord.
Allegedly, no, there is evidence. There is evidence of your co-accused
No,
there.
my lord, it was never proved.
No. There is
Yes.
material.
On the
Is
matter,
this judgment under stay?
my lord,
Has this conviction being, has the sentencing being stayed by this court?
no, my lord.
Where are you now?
My lord, that I will have to verify with the jail because the judgment was passed on 24 January.
Naturally.
Yes.
You are
so-
behind bars.
Yes, he was sentenced, I was sentenced for 1 year
1 year only,
rigorous.
that's right.
So 1 year has already lapsed, so if I may be allowed to verify with the jail whether I am still in jail or not.
But the stigma would be there.
Yes.
Nothing is here. Your own people went against you. Luckily, you were not entangled in that heroin. Heroin was also unearthed in that vehicle wherein the drinks were being brought for you.
No, my lord, I beg to differ. However, in the statements given by my co-accused before the magistrate, my lord, they did not say that the...
No, I'm here. Okay, fine.
The
That
whole
is
liquor was not mine, to be fair.
No, the heroin was not yours. There is
No, heroin was not mine, true. but
Your
the whole
case
liquor
is
of-
simple that you know those two people, they have taken your name out of fun and they have brought you in. That's all.
Yes. it was
That's
a
your
conspiracy- It was
statement.
a conspiracy, my lord, it was never proved.
On a prayer made on behalf of Ms. Mary Puranampulihiriva, learned additional public prosecutor, learned for an adjournment today on account of personal inconvenience, registry to list this matter again after 2 weeks on a date to be fixed by. After 1 week,
My lord,
2 weeks. 1 week?
if the 2 weeks is
2 weeks.
Yes, my
Okay,
lord.
2 weeks.
Item number 9.
obliged.
May I please your lordship. In this case, my lord, the LCR has arrived. LCR was called for on the last occasion. This is an appeal against the judgment order arising out of money suit. And perhaps paper book.
Money suit.
Yes, my lord.
Service is complete.
1 to 4 duly represented, my lord. As for the respondent number 5, my lord, I have taken Dusty's.
Dusty, huh?
And on this 2511, this court had already held a notice upon the said respondent himself.
So why is it coming up for orders again and again?
LCR was awaited.
LCR has not come.
It has arrived.
It has come. It
Just
is submitted that the where was the service on respond number 5 accepted?
Your lordship may kindly see order dated 2511.
2511. Okay. Submitted that the notice served upon the respond number 5 by way of Dusty mode was accepted by this court on 25/11/2024. Accordingly, the service of notice upon all the respondents is complete. Further, the lower court records as called for has also been received. Accordingly, registry to list this matter again in the again on when?
Subject
26.
Subject to preparation of the paper book, my lord. Paper book will be required.
No, first it has to be admitted.
Yes, madam.
It has not been admitted, I suppose?
Not yet, not yet.
Then appeal is admitted, okay. Appeal is admitted, no, appeal is admitted, no problem. Registry to prepare the paper book. Full stop. The appeal be listed for hearing after preparation of the paper book. Full stop. Okay?
Deeply obliged.
Item number 12.
May it please your lordship. Lordship, I'm appearing for my on behalf of my senior, Mr. Jesse, my lord, and it seems that in the present case that LCR has not yet been received and it's still being awaited, my lord.
What is the matter?
My lord, this is a regular first appeal.
Nah, that I can understand. But what is the meat of that matter? You did not have time to go through it because you had only had to say this. Next time you appear before me, I'll require the facts.
Yes, my lord.
Otherwise, I'm not going to adjourn any matter. Be that as it may, whatever the thing would be.
Yes, my lord.
Okay?
Yes, my lord.
Get a brief, read that.
My lord, if I
In the office, yes ma'am?
yes, my lord, if I may be allowed to make a small prayer, my lord. On page 57 of our memo of appeal, our interim prayer has been mentioned, my lord. So, if this interim prayer may be granted by this.
Then you will have
honorable
to, you will have to argue the matter for before me. It's not for asking. Next date, prepare, come, we will consider. Seen the office note dated 10/3/2025, which reveals that the LCR has not been received. Registry to issue fresh requisition for requisition calling for the LCR from the court concerned. Full stop. Registry to list this matter on after 3 weeks along with the LCR.
Deeply obliged.
Item number 13.
13.
Your Lordship, I have been requested by Mr. Mahajan from Guwahati that this matter may be listed next week because he is having some
Lucky. I was ready, 37, not satisfied.
Yes, Lordship.
Simple. Nothing more, nothing less.
Very true,
The Supreme Court decisions are also, it's all noted down. I would have passed the other thing. As prayed for by the Learned Council for the applicant, petitioner. Petitioner बोलते हो ना bail application में यहाँ पे? Applicant, you call them a applicant or a petitioner? How do you describe a applicant here?
Petitioner or
Petitioner,
petition?
comma, not objected to by the Learned Council for the respondents, comma, raised it to list this matter on a date to be fixed by it next, after a week.
Also,
After 2 weeks.
yes, also my presence may be reflected because I'm representing, yes.
You just give your name.
Yes,
Mr.
Johnny L.
So-and-so,
Tochong.
Learned Council appearing for the respondents is present. Not objected, Mr. So-and-so has not objected, Kadana. Yes.
I am obliged.
Item number 14.
After 1 week or 2 weeks? 1 week. 1 week, after 1 week. 61 days.
Yes, my lord. My lord, till date, we have not received the RTI till date. The main reason for our delay is
Okay, fine. If they don't object, we will not go, but that,
Yes, my lord.
the present interlocutory application has been instituted, praying for condonation of a delay of 61 days occasioning in preferring the connected appeal, assailing the order dated 4/10/2024, passed by the learned civil judge, bracketed civil senior division, bracket over, -2, ISOL in civil suit number 38/2018. Full stop. Issue notice, full stop. Petitioner to take steps for service of notice upon the respondent's number will have to go for all,
Yes, my lord.
for the respondents by way of, or any government advocate appearing who will take notice for 2 to 6. None. You'll have to take steps.
Yes, my lord.
You
I'll
could
take
have had a
steps.
government advocate, he could have taken these steps. Madam, can you take steps? Can you take notice for 2, 3, 4 and 5? Show her, she'll not know. You have a copy?
No, Your Lordship.
Give her a copy. You are a government advocate, madam?
Yes, Your Lordship.
Can you appear for the Land Revenue and Settlement Department?
Yes, Your Lordship.
Director, Land Revenue,
Yes, Your Lordship.
Settlement Officer, you can,
Yes,
okay.
Your Lordship.
ऊपर में लिखना तो heard Mr. So-and-so, also heard Miss So-and-so, Learned Council, appear, government advocate representing the respondents number 2 to 6, huh?
Yes, Your Lordship.
उसके बाद लिखना ये application, this is this, issue notice. Miss So-and-so accepts notice on behalf of respondent number 2 to 6. Petitioner to furnish extra copies, requisite extra copies of the interlocutory application to the learned government advocate. Full stop. Petitioner to take steps for service of notice upon the respondent number 1 by way of registered post with AD. Steps within 3 working days from today.
Deeply obliged, my lord.
Register to list this matter after 4 weeks.
Obliged.
Item number 15.
1 to 4 has got no objection.
Yes, Your Lordship, no objection.
But what about 5?
5 remains unrepresented, my lord. It's basically a pro forma respondent, my lord. I had brought my land from the respondent number 5,
5, that's it.
my lord.
I think we can, or should we wait for a date? Because therein these notices have not come back till now.
Exactly, my lord.
So,
AD card has not returned.
not reflected. So I think we wait for a day. Because otherwise again, if he doubts your status again, that would be a problem, because if there is a doubt, dispute created, I'll have to refer the matter back to the lower court.
My lord.
Order 22 rule, how much? Order 22 rule, CPC. I've been learning this after I became a judge. It's order 20,
22 Rule 3, my lord.
Rule, no. 5, I suppose, 5. Determination of question as, where a question arises as to whether a person is or is not the legal representative of a deceased plaintiff or a deceased defendant, such question will be determined by the court, provided that where such question arises before the appellate court, that court may, before determining the question, direct any subordinate court to try the question and to return the records together with evidence, if any recorded at the tried so and so, so and so. Okay. Main में लिखना.
My lord, here the applicant is the wife of the appellant. I have annexed the marriage
Marriage
certificate also.
certificate. Okay, let us not have any. Yes, madam.
Yes, Your Lordship. On behalf of the
When
respondent.
were the steps taken upon the respondent number 5?
My lord,
Can't you take Dasti?
as per office note in the main appeal, my lord, AD card has not returned.
No, can't you take Dasti upon the respondent number 5?
I can, my lord.
Take Dasti.
My lord.
Learn it. Full stop. IMM लिखना. The learned counsel for the applicant also heard madam का नाम लेना. Learned counsel appearing for the respondents number 1, 2, 3 and 4. Full stop.
2, 3 and 4, Your Lordship.
2, 3 and 4. Sorry, 2, 3 and 4. One has been served.
One has been served, my lord.
Okay. No, in this this one.
Yes, my lord. In the IA and in the
No, where IA notices were not issued.
Sorry, my lord, this is the first time this IA is come.
Heard so and so, learned counsel representing respondents number 2, 3 and 4. Full stop. The present application has been filed by the applicant praying for substituting herself in place of the original appellant, who was her husband. Issue notice. Ms. So-and-so accepts notice on behalf of respondent number 2, 3 and 4. Requisite extra copies of the application be furnished to Ms. So-and-so by the learned counsel for the petitioner. Full stop. Petitioner to take steps for service of notice upon the respondent number 1 and 5 by way of registered post with AD as well as by way of by Dasti mode.
If I may interject, my lord, the respondent number 1 is already represented in the main appeal, so I believe
No, who is?
they are absent, my lord. I believe they.
You have given a copy.
I've
to
given
them?
a copy in advance, my lord. I think it will be in the court copy, my lord. The receipt.
Mr. Malhotra is appearing. No, Malhotra
No,
is for you.
Miss Ruth Larwat-Feli or Mr. Elish Lianshima, senior counsel.
Where is that notices kept? Okay. ये करो. ऊपर में लिखना. Miss so and so accepts notice on behalf of respondents number 2, 2, 3 and 4 लिखा है ना? उसका आगे में लिखना. Notice for service, a notice of the interlocutory application has been served on the learned counsel for representing the respondent number 1. उसके बाद 2, 3, 4. हाँ? Petitioner to take steps for service of notice upon the respondent number 5 by way of registered post with AD as well as by Dasti mode routed through the registry of this court. Full stop. Steps within 3 days. Registry to list this matter again after 2 weeks. Full stop. Main appeal में आना. Heard the learned counsel for the parties. एक ही होगा तीनों. Learned counsel for the parties. Full stop. It is found that the notice upon the respondent number 5 has not been served till date. Full stop. Accordingly, the learned counsel for the appellant is directed to take fresh steps for service of notice upon the respondent number 5 by way of registered post with AD and also by way of Dusty mode routed through the registry of this court steps within 3 working days from today. ऊपर वाला में भी लिख देना 3 working days from today. Registry to list those matters again after 3 weeks. You filed it, make a mention, we'll have it. Or you want 2 weeks?
My lord.
2 weeks or 3 weeks?
2 weeks, my lord.
2 weeks.
Oblige.
But it will depend on your Dusty.
My lord.
Hearing list, item number 12.
I think they made a mention yesterday, no? For today. Yes.
Yes, Your Lordship. Your Lordship.
Take an appearance of all the names. Their names you just note down. The parties, councils, with respondent numbers. Yes.
Yes. Your Lordship, this is an appeal against the judgment and order dated 17/10/2023, passed by the learned member cum presiding officer, MSCT Aizol in MSCT case number 19 of 2023. Your Lordship,
This is the last one or any other matters? Huh? No other, any other matters being listed, any others will be taken up or this is the last item? Last, okay. Hey, Miriam, ja maalo. MSCT number 19, na?
19 of 2020, Your Lordship.
Okay.
Your Lordship, before I go to the facts of the case, paper book has not been prepared in this case. So will it be difficult to conduct hearing?
No, why did you?
My lord, that would be too late in the day because it can be disposed by looking at the
You should
record.
have made that prayer before.
Yes, Your Lordship. Then the facts of the case leading to filing of the instant appeal is that on 22/1/2020,
You are for the insurance.
yes, Your Lordship, the insurance company. In the instant case, the 2 vehicles are
Just a
involved.
moment.
Yes, 2 vehicles are involved. One is
Just a moment. You have not even prayed for a paper book, so that we are not allowing you.
previously we made a prayer, but it was objected to by the opponent counsel. So that's why no paper book has been prepared.
It's reflected that the LCRs were noted, receipt of the LCRs was noted, and you all prayed for fixing the matter for hearing. That's all. Yes, right?
Yes, right, my lord.
Yeah.
Your ground is that the, what do you call that, driver?
Yes.
That's the only ground.
My main ground is that there is no proof of negligence on the part of the driver of the truck. 2 vehicles were involved in the said accident. One is a truck, and the other
And
one is
the truck was insured with United India.
yes, the appellant,
And the other one is National Insurance.
National Insurance Company.
Okay. The National Insurance is a party here?
Yes, Your Lordship.
Who is representing National Insurance? Okay. How was it apportioned? Amount was apportioned between the two?
No, it has to be borne by the appellant.
Lordship, in this regard, there is no contributory negligence
From
on the
on
part
the
of the, yes, on the
other
part of
vehicle.
the, yes, other vehicle. So the evidence says that the faulted driver was the truck. So there is no fault on the part of the one of the vehicle, Your Lordship, which was insured with the National Insurance Company.
Is there a stay order operating?
Pardon,
Is
Your
there
Lordship?
any stay order operating?
No, there is no stay order, Lordship.
Money have deposited?
Has not been deposited.
Okay, what is your ground? ऐसा कैसे होगा? Have you not even had the time to make a small index for this? It would have been very easy, only that is the point left, right?
Yes, my lord.
Whether there is a contributory negligence, accident is there. There was a death occasioning of a boy.
Yes.
Yes, my lord. My lord, if I may
Yeah, please.
interject at this point. If you look at the written statement of the appellant, he did not claim, my lord, he did not claim any other grounds which he could raise apart from Section 149. So his appeal is very limited at this stage. If your lordship will see Section 149 MV Act, 1988, and Section 170 MV Act,
Okay.
he may try to raise other points which is not permitted by Section 149.
Okay. Will not allow him to go beyond 149.
My lord.
Yes.
Yes, Lordship.
Where is the charge sheet?
Charge sheet is at Annex 14 of the claim petition, Your Lordship.
You do one thing, Mr. Counsel. We'll take it up tomorrow. Whatever documents you want to rely,
Yes.
you just put a mark,
Yes.
sign it up. We'll take it up tomorrow.
Okay.
Others, again, it will be, I'll have to go and searching for this. Tomorrow we'll take it up. We'll take it up tomorrow.
My lord.
But let him, whatever documents he wants to rely, let him have.
My lord, can it be taken up at first item, as first item?
Tomorrow we'll have, I'm here tomorrow.
My lord.
Give me this file today. The records you can keep back here. I only one day. Case records, case file. LCR, before you, let him make those markings, whatever he wants. It's okay. Just put in order next week. Tomorrow.
Tomorrow.
As agreed to by the Lanark Council for the parties, list this matter again tomorrow. I'll pass it over. So we are having it tomorrow. After immediate, if there are hearing matters, let's see. If we can accommodate you before the hearing matters in the part 1 list, we'll take it up.
My lord.
Okay? Just remind me, I forget.
My lord.
No need. Oh, no need. This will be coming up otherwise also tomorrow. No order be passed. Nothing. We'll take it up tomorrow. No order will be passed. It will come up automatically tomorrow.
My lord.
Just remind me in the morning. Okay.